the early hours of July 11th, 1958, Mildred and Richard Loving were sleeping peacefully in their home in Central Point, Virginia, when three Caroline County police officers entered their bedroom shining flashlights. The couple was arrested for breaking Virginia's anti-miscegenation laws. Richard was a white man, and Mildred was a colored woman, and in the state of Virginia, it was illegal for people of different races to be married. Just that spring, the two went to Washington, D.C., where interracial marriage was legal, to get married because Richard knew they couldn't get married in Virginia. However, he did not know you could not leave the state to marry and return. They were taken to the jail nearby Bowling Green. Once released, they both stayed at their parents' house. They were charged with violating two Virginia statutes, leaving the state to evade the law when they married in Washington, D.C., and for a marriage between a white person and a colored person. The Lovings pled guilty on the advice of their lawyer, who hoped the judge would be lenient on them if they entered a guilty plea. In January 1959, Judge Leon M. Bazile found them guilty and sentenced them to 1 year in prison, but would suspend the sentence on the condition they leave the state of Virginia for 25 years. They could not be together in Virginia, so they had to move to Washington, D.C. Separated from their friends, family, and their home, they were only allowed to visit their family in Virginia, only individually, and not with each other. Richard was a bricklayer and Mildred was a homemaker. They did not have a lot of money to hire an attorney to appeal the case or fight the court order. In 1964, tired with their situation, Mildred's cousin suggested they contact Attorney General Robert Kennedy, who may be able to lift the court order. Mildred wrote a letter to Attorney General, who advised her to contact the American Civil Liberties Union for help. Two ACLU lawyers, Bernard Cohen and Philip Hirschkopf, also felt that the Lovings should be able to marry and to live in the state where they wanted to. They agreed to work on the Lovings case for free. The Lovings did not realize the magnitude of their case. They just wanted to live together in their hometown as husband and wife. The ACLU lawyers had the case reopened at the Caroline County Court where they had first been tried. Cohen filed a motion for the charges to be dismissed because the Lovings' arrest was unconstitutional, and he cited the 14th Amendment's Equal Protection Clause. The trial judge, Leon M. Bazile, refused to dismiss the charges. He cited cases from the 1800s, which found whipping and being sold and exiled supported his view that the Loving sentence was not cruel and unusual punishment. He concluded with the following infamous racist rant. Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents, and but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. The Lovings' attorneys had not expected that the charges would be dropped. Therefore, they were ready for the next step. They filed a motion in federal court, but the court ruled the case had to exhaust all of the Virginia state remedies before entering the federal court. Meanwhile, the federal court ruled that the Lovings could move back to Virginia without being arrested, while the case was moving its ways through the levels of the legal system. The ACLU lawyers filed a notice of appeal with the Supreme Court in July 1966. The lawyers built an argument that the racial integrity statute of Virginia, of which the Lovings had been convicted of violating, was discriminatory and denied due process and equal protection guaranteed under the 14th Amendment. Additionally, Hirschkopf and Cohen explained how the law was disrupting the Lovings' lives. They couldn't live together in their hometown with their children. Their children were illegitimate because their parents' marriage was not valid. If one of them died, the other could not receive Social Security survivor benefits. The children would not automatically inherit their parents' property if the parents died. These were rights denied because of their race. On Monday, April 10, 1967, oral arguments for the Lovings case were presented at the Supreme Court. The ACLU lawyers used the following 6 arguments for the case. The entire 10 sections of Virginia's anti-miscegenation code should be abolished. Based on their history, Virginia's laws against interracial marriage were relics of slavery and expressions of racism. Laws against interracial marriage caused immeasurable social harm. Despite the historical record, the 14th Amendment did not exempt state anti-miscegenation laws from its requirements. Virginia's laws against interracial marriage were racially discriminatory and denied the Lovings of equal protection of the laws. The laws also violated the 14th Amendment Due Process Clause. Virginia Assistant Attorney R.D. McElwain represented the state of Virginia. The state had built their case around two key points. One, the framers of the 14th Amendment did not intend to infringe upon the states to ban interracial marriage. Such laws were already in place at the time. Secondly, even if the court ruled that the 14th Amendment did not apply to interracial marriage laws, Virginia's laws served again a legitimate legislative objective of preventing the sociological and psychological evils which attend interracial marriage. McElwain attempted to convince the court that Virginia had the best interests of the children in mind. McElwain's arguments did not impress the justices, who had to concede many points when the justices. On June 12, 1967, in a unanimous decision, the justices overturned Virginia's code on interracial marriage. The Lovings were now free to live as a married couple in their home state. Chief Justice Warren presented the opinion of the court. The court held that distinctions drawn according to race were generally odious to a free people and were subject to the most rigid scrutiny under the Equal Protection Clause. The Virginia law, the court found, had no legitimate purpose independent of invidious racial discrimination. The court rejected the state's argument that the statute was legitimate because it applied equally to both blacks and whites and found that racial classifications were not subject to a rational purpose test under the 14th Amendment. The court also held that the Virginia law violated the Due Process Clause of the 14th Amendment. Under our Constitution, wrote Chief Justice Earl Warren, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. Justice Stewart concurred and expressed that it is simply not possible for a state law to be valid under our Constitution, which makes the criminality of an act depend on the race of the actor. In other words, a generally legal act cannot be illegal based solely on the race of the person. The case affirmed that marriage was a fundamental right. States no longer had the right to restrict interracial marriage. 16 states had laws against interracial marriage at the time of the Loving decision that were no longer enforceable. This victory did not only apply to black and white people, but to all other interracial couples who wanted to marry. The number of interracial marriages has grown since the groundbreaking case. According to the 2010 census, there are 5.4 million mixed-race couples, a 28% increase from 10 years earlier. I spoke with my mother, Julie Gilner, a child of an interracial marriage herself, a white father and an Asian mother, who married my father, a black man. She recounted reaction of family and friends when they found out about her relationship with a person from a different race.
I think if anyone had negative thoughts about Brooke, they kept it to themselves, except for my mother. She always held strong negative opinions of people based on their race. She disliked black people and believed every stereotype. When she met Brooke, she insulted him by yelling expletives. Due to her hatefulness, we stayed away from her.
In present-day civil rights, many people feel the legal fight over same-sex marriage is an echo of the old laws banning marriage between white and black people. Generally, issues against the same-sex marriage are similar to Virginia's McElwain had argued. He stated it was not in the best interest of the children, or that these marriages cause social and psychological harm. These arguments are just unimpressive now. Gay marriage advocates are using racial justice cases such as Loving versus Virginia for their cause. Many of the same points can be made for the rights of same-sex couples. Just like the Lovings, the inability of same-sex couples to marry makes them second-class citizens and denies them their civil rights. Surprisingly, when interviewing Professor Linnell, he told me Mildred Loving's opinion.
Miss Loving actually did not believe in same-sex marriage. That's not very well known, but it's a fact. She was a fundamentalist Christian.
After 9 years and 10 days of unlawful marriage, the Lovings returned home to Central Point, Virginia. They never intended to be famous. They just wanted to be together.